My name is Rob Wiley, and today I'm going to be speaking with Austin employment lawyer Colin Walsh about the Family Medical Leave Act. So Colin, someone has a serious medical condition and they need to take time off work to deal with it, be it a car crash or be it a cancer treatment. What kind of rights does an employee have to take leave from work because of a serious medical condition?
Well, first, an employee does have a right to take leave for a serious medical condition. That's protected by the Family and Medical Leave Act. And that act provides up to 12 weeks of unpaid leave to deal with a serious medical condition.
Now, as I understand it, not all workplaces qualify, and not all employees qualify for that either. What are the threshold requirements to be able to qualify for family medical leave?
Well, threshold requirement for an employer would be 50 employees within 75 miles. So it's not going to protect smaller employers. The requirements for an employee would be that employee has to have worked there for a year and must have 1,250 hours of work in that job before they qualify.
And so when we talk about 50 employees within 75 miles, that's of the work site of where they were physically working, is that correct?
Yes, that's correct.
Okay, and so you said that it was unpaid leave. Does that prohibit an employee from also being able to use vacation time or some sort of paid leave that they're entitled to, as well as FMLA leave?
No, it does not prohibit an employee from using paid leave at the same time as FMLA leave. In fact, I would say that most employers, if they don't require it, encourage it.
Now, in terms of getting these 12 weeks off, how often do you get to take FMLA leave?
Every 12 months.
So every year you get this additional, I guess, right to 12 weeks of FMLA leave if you qualify under the law. One of the things we talked about was a serious medical condition, but that doesn't just have to be for the employee, does it? Who can an employee take leave to take care of?
You're right. The FMLA does not protect just an employee, but the employee's spouse, child, or parent if they have a serious medical condition.
So if your child is sick and you need to stay home to take care of that child, that's exactly the kind of leave that would be covered. Is that correct?
Yes, absolutely.
Obviously, sometimes people want to take a big block of time, take off work, recover for some sort of very traumatic type injury. But we also see some people that need an hour here, an hour there to deal with a chronic condition or something like that. Would the FMLA protect people who need to take that leave over time?
Yes, the FMLA would protect those people. They would call it intermittent FMLA leave, and that allows an employee to use little blocks of those 12 weeks over a long period of time.
And I guess before taking FMLA leave, you probably need to give your employer some sort of notice. What does the law have to say about that notice requirement? So
an employee in an ideal world, in best case scenario, would give the employer at least 30 days of notice. However, emergencies do happen. And so what the law says is that as long as you give the employer as much notice as possible, you're going to be protected by FMLA leave.
Now, I think that the FMLA has a couple of protections in there. One is, of course, while you're off work, can they interfere with this time that you have off? Can they call you up, tell you to come back in for a day, things like that?
No, they cannot. They cannot interfere with your FMLA leave.
And so at the end of your FMLA leave, you want to return to work. Does the employer have to return you to work even if they found someone else to fill in for your position while you're gone, a new employee?
Yes, the employer is going to have to return you to your job or a job that is essentially the same as the one you left. That's the whole point of FMLA leave.
Right, I've actually heard it described as it's not so much the right to take the leave, it's the right to come back afterwards to the same or equivalent position, and certainly also to be making the same amount of money. Now, something that I've seen some employers do that's very, very sneaky is they might have an employee who has worked for them for some period of time, maybe 11 months, and so they don't qualify for FMLA leave yet, and they know that the employee is going to want to take FMLA leave once they hit the 1-year mark. Can an employer preemptively terminate somebody to prevent them from qualifying for FMLA leave?
No, that would be a violation of the FMLA to preemptively fire somebody for wanting to take FMLA leave.
And I think the FMLA is one of those things where it is particularly helpful to have an employment lawyer represent you because you're going to be going to the employer and you're going to be asking for leave, which always raises the specter of retaliation. Ideally, HR would do everything they're supposed to do, and they should give you leave and welcome you back with open arms. But we all know that that doesn't always happen in the workplace. So getting a lawyer involved ahead of time, as opposed to after you're starting to experience retaliation, that can be very helpful.
I would agree. I would say getting an employment lawyer involved as early as possible in the process is going to be very helpful.
And this is something that's been surprising to me too. In terms of the violations that we see, we probably see more violations involving age discrimination, people over 40, pregnancy discrimination, and FMLA leave. That is an area in which once employees signal a need to take leave or want to take leave, everything changes, and they find themselves pushed out of a job, fired, or the terms and conditions changed in a way that it is no longer the job that they enjoyed doing.